There is a version of the law most of us grow up understanding. Don't steal. Don't harm people. Simple rules that make sense the moment you hear them. You don't need a government to explain why hurting someone is wrong. You already know it. But then there is another version of the law, one that has been quietly sitting in legal books for decades, sometimes centuries, collecting dust in courthouses in countries you've visited, cities you've walked through, airports you've passed through without a second thought. These are the laws that make you stop and stare. The kind that make you set down whatever you're holding and say out loud to nobody in particular, what on earth happened for someone to decide this needed to be written down? That is what tonight is about. Not the quirky trivia night facts. What I want to talk about goes deeper. Because behind every bizarre law, there is a reason. And sometimes that reason is funny. And sometimes that reason is deeply uncomfortable. And sometimes it reveals that the world has always been a much darker and stranger place than the version of it we were raised on. Every law I'm about to walk you through is real. Every single one was written by actual human beings who believed this rule needed to exist. And in most cases, nobody ever officially got around to removing it. The law has memory. It holds on to the past with a grip that nothing else in society quite matches. Politicians change, buildings get torn down, but the law just sits there, patient, permanent, waiting. The town where you cannot die. There is a remote Arctic settlement called Longyearbyen on the Norwegian archipelago of Svalbard, roughly halfway between mainland Norway and the North Pole. In Longyearbyen, it is technically illegal to die. This is not a philosophical statement. It came from something far more concrete and far more unsettling. The ground in Longyearbyen is permanently frozen. Permafrost. It never thaws. When a body is buried there, it does not decompose the way it would anywhere else. It is simply preserved, indefinitely, exactly as it was at the moment of death. In the late 1990s, researchers made a discovery that sent a specific kind of chill through the scientific community. Bodies of people who had died during the 1918 Spanish flu pandemic were exhumed from the Longyearbyen cemetery and found to still contain active, viable samples of the influenza virus. Frozen for 80 years, still intact, still theoretically capable of infecting a living host. The ground in this town is so permanently frozen that a virus which killed an estimated 50 million people worldwide was still alive inside buried corpses 8 decades later. The town's response was to quietly stop burying people there. The law, which had existed in some form since the 1930s, remained in place. If you are terminally ill and you live in Longyearbyen today, you are required to travel to the mainland to die. Nobody knows exactly how many bodies remain in that permafrost. Nobody knows exactly what else the ice is preserving down there. The law remains in effect. The Salmon Law. In England, Section 32 of the Salmon Act of 1986 makes it a criminal offence to handle a salmon under suspicious circumstances. That is the actual legal language. Suspicious circumstances. It does not define what suspicious circumstances involving a salmon look like. There is no checklist. The maximum penalty for violating this law is 2 years in prison. The origin was serious. It was designed to prosecute people receiving or distributing illegally caught fish when direct evidence of the illegal fishing itself was hard to establish. A broad legal net, deliberately vague, intended to give prosecutors flexibility. What it actually created was a law that technically applies to anyone holding a salmon in a way that someone else finds questionable. And because it has never been successfully used in a modern prosecution, it has never been tested in a higher court, which means nobody actually knows where the legal boundaries of suspicious salmon handling begin and end. The law is essentially undefined, sitting there, waiting. What makes this unsettling is not the salmon. The salmon is funny. What is unsettling is what it reveals about legal systems broadly. Every country's legal code contains provisions exactly like this. Broadly written, poorly defined, never tested, never removed. Language drafted in a specific context to serve a specific purpose, which then outlasted that context by decades. Every time you have been told that ignorance of the law is no defense, remember the Salmon Act. Somewhere in the legal code of the country you are standing in right now, there are almost certainly laws you have never heard of, cannot reasonably be expected to know about, and may be unknowingly violating at this very moment. The Smiling Law. In Milan, Italy, a municipal regulation requires all citizens to smile in public at all times. It is a real local ordinance, dating to the period of Austro-Hungarian influence over northern Italy. It was never formally repealed. It technically remains on the books today. The exceptions built into the law are more interesting than the law itself. You are not required to smile at funerals, and you are not required to smile in hospitals. Those are the only two situations the original authors decided justified letting your face show something other than contentment. Think about what that list reveals. They looked at the full spectrum of human experience, all the grief and frustration and exhaustion that a person might feel in an ordinary life, and decided that exactly two situations warranted it showing on your face. Everything else, they concluded, should be accompanied by a smile. It is easy to read this as a charming historical artifact, but there is another way to read it. There have been periods in history, and there are places in the world today, where the requirement to perform happiness in public is not a forgotten ordinance that nobody enforces. Where the gap between what a face is allowed to show and what a person actually feels has been deliberately engineered and rigorously policed. The Milan Smiling Law is enforced by nobody, violated constantly, essentially meaningless. But it is a relic of something, a written record of a time when the emotional expression of the population was considered a matter of public governance. The law never said you had to be happy, it just said you had to look it. The code that punished everything with death. In the 7th century BC, Athens appointed a man named Draco to write down the law for the first time in Greek history. Before him, Athenian law was a collection of oral traditions and family feuds that varied depending on who you were and who you knew. Writing it down was supposed to fix that. Equality under a written code. Draco wrote the law, and the law he wrote prescribed death for almost everything. Stealing a cabbage? Death. Being idle, defined as having no visible means of income? Death. Minor theft. Debt under certain circumstances. A range of offences that in any other framework would have warranted a fine received. Under Draco, an execution. When asked why minor offences carried the death penalty, Draco reportedly replied that minor offences deserved death, and he could not think of a more severe penalty for serious ones. This is the origin of the word draconian. It entered the English language directly from this man's name, from this specific moment, because the laws he wrote were so disproportionately brutal that they required a new word to describe them. The word survived. The laws were largely repealed shortly after his death by a reformer named Solon, who kept only the statutes concerning murder and replaced the rest with something less catastrophically severe. But here is what matters. Draco's code was the first. Everything that followed, every legal tradition in the Western world, tracing its lineage through Rome and Greece, every codified system of justice that exists today, descends in some direct line from what Draco wrote. The entire edifice of Western law began with a document that killed people for taking a vegetable. The law that let you club a Swede. In 1658, Swedish King Charles X Gustav did something his enemies considered impossible. He marched his army across the frozen strait between Denmark and Sweden in the dead of winter and arrived on the Danish side before anyone had thought to prepare a defence. The Danes, waiting for the fighting season to resume in spring, were caught completely off guard. The resulting peace treaty forced Denmark to cede significant territory. The Danish response included, at some point in the nation's legal history, a law stating that any Dane who encountered a Swede crossing the frozen Öresund was legally permitted to strike that Swede with a stick. This law remained on the Danish books for a very long time. Its current legal status is genuinely unclear. What is not unclear is that it existed. That a group of Danish legislators sat down and decided the correct official response to a military defeat was to write stick-based assault into the legal code. Laws written in anger are their own category of strange. They are not the product of careful civic deliberation. They are emotional. They encode a feeling, a wound, a moment of humiliation, and they preserve that moment in legal language long after everyone who felt it has turned to dust. Decades later, a new generation inherits the law without the emotion that produced it. The anger is gone. The offence has receded into history textbooks, but the law just keeps sitting there. The Öresund has frozen solid enough to cross on foot only a handful of times in recorded history. Nobody is currently staging a winter invasion, but the legal permission to respond to one with a stick was real, and may technically still be. The house that was legally haunted. In 1991, a New York court ruling created what legal scholars sometimes call the Ghostbusters ruling. Jeffrey Stambovsky purchased a house in Nyack, New York, and discovered that the seller had publicly and repeatedly claimed for years that the house was haunted. She had written about it in a national publication. She had told local media. The house had a documented, well-publicized supernatural reputation that she herself had created and promoted. Stambovsky, who had moved from New York City and was unfamiliar with the local reputation of the property, argued fraud. The seller had manufactured a condition through her own public statements and then failed to disclose it to a buyer. The New York Appellate Division agreed. The court determined that because the seller had herself established the haunted reputation, and because that reputation had measurable real-world consequences for the property's value, she was legally obligated to disclose it. The court's written opinion included the line that the house was, as a matter of law, haunted. A New York court declared a house legally haunted. It is in the official record. It cannot be undone. The ruling established a legal duty to disclose what are now called stigmatized properties. In plain language, if your house has a documented dark reputation, whether from a crime, a death, or a publicly cultivated claim of supernatural activity, you may be legally required to tell a buyer before the sale. The house in Nyack still stands. It has changed hands multiple times since. Whether each subsequent buyer was properly informed of its legal status, the record does not say. The Ancient Tax on Urine. The Roman Emperor Vespasian, who ruled from 69 to 79 AD, found revenue in places other rulers had not thought to look. When he came to power, the empire's finances were depleted. He needed money quickly. He taxed urine. Human urine, in the ancient world, was a genuine commodity. It contained ammonia, which made it useful to tanners processing leather and launderers cleaning fabric. Both industries depended on it. Public collection points existed throughout Rome to supply this market. Vespasian looked at it and introduced a levy on its collection and sale. His son Titus protested publicly, finding the whole arrangement undignified. Vespasian's response became one of the most quoted lines in Roman history. He held up one of the first coins collected under the new tax and asked his son, "Does this smell?" The answer, Titus had to admit, was no. The phrase entered Latin as pecunia non olet. Money does not stink. It is still in use today, roughly 2,000 years after a Roman emperor coined it while defending his right to tax urine. The tax generated enough revenue that Vespasian used the proceeds to fund construction projects across Rome, including, in a detail of almost perfect historical symmetry, public latrines. Public toilets funded by a tax on the contents of public toilets. The Romans, whatever else you want to say about them, knew how to close a loop. What the laws leave behind. Every law on this list was written by human beings trying to solve a problem. Some problems were trivial, some were serious, some were genuine crises. Diseases in the permafrost, market manipulation at sea, military humiliation, the bodies of enemies frozen in a strait. Some were responses to fears rather than facts, anxieties about what might happen without this specific rule in place. The law does not sort any of this. It holds the rational and the irrational together with the same flat, patient grip. The carefully considered and the hastily enacted. The still relevant and the centuries obsolete. All of it in the same books, waiting. What strikes me most is not the content of these laws, but their age. Every one of them was, at some point, brand new. Someone drafted the language, someone in authority signed it or proclaimed it, or had it carved into stone. It was fresh and relevant, and people adjusted their lives around it. And then time passed. The world changed. The people who wrote the law became dust and history and footnotes. And the law just kept sitting there, unchanged, patient, waiting for the next person to stumble across it. The laws that make you laugh are not actually funny. They are fossils, preserved remains of a world that no longer exists, embedded in the legal code of a world that does. And the reason they survive, still technically in effect in many cases, is simply that nobody got around to removing them. Nobody had the time or the inclination or the political motivation to open the book and cross out the line. So the line stays. The fish must not be handled suspiciously. The bodies remain in the permafrost. Somewhere in Danish legal archives, there is a document granting permission to hit a Swede with a stick. A New York court document declares a house on the Hudson River to be, as a matter of law, haunted. The law remembers everything, even the things we have long since forgotten we ever thought needed remembering.